Yes, Mr. Marshall.
Thank you, sir. Mr. Dixon, I'd like to turn now to information sharing between agencies. Can we start, please, with paragraph 178 on page 47 of your statement? And it comes to this, doesn't it, that you explain there that the department recognises that poor and ineffective multi-agency working, including information sharing, is effectively a perennial issue and a key factor where child protection activity fails to keep children safe.
Yes, that's right. In the majority of reviews, that is flagged as an issue.
Yeah. So one that you see coming up in different contexts in a number of different ways, but that is a constant problem.
Yes. Or a constant point of failure, I suppose.
Yeah. Thank you. And so for your note, paragraph 191 also, Ms. Dixon, I think you say there, poor information sharing has contributed to serious child safeguarding incidents over a prolonged period. Is that right?
Yes, that's right.
Yes, thank you.
Now, taking matters shortly, your statement deals with the guidance that's in place, and you set out in particular the concern that the data protection legislation shouldn't be standing in the way and acting as a barrier to appropriate sharing, because as professionals who are immersed in the detail will appreciate, there are appropriate exceptions that permit the sharing of information where it's necessary and appropriate to do so in relation to risks of self-harm and risks of attack to other people. Would you agree?
Yes.
You say in paragraph 152, having briefly set out a summary of what you say the problem is from your statement, you say in paragraph 152 at page 42 that the department is currently taking the Children's Wellbeing in Schools Bill through Parliament, which further enshrines this multi-agency approach to keeping children safe. This includes the establishment of new multi-agency child protection teams and a new duty to require multi-agency information sharing between partners when there are concerns about a child. Can you just explain just a little bit more what the bill will actually change, what its purpose is, what will be different? Because the sceptical view might be that should all be clear already.
I think it's a bit of both, really. So the bill will seek to clarify exactly what you've just set out, really, so that the safeguarding duty overrides any misconception that there is confidentiality around data protection, that's the overriding imperative to share, that the duty exists to share but also gives the right to request, and then multi-agency child protection teams are a slightly different point, but that is also in the bill, and that is strengthening those arrangements. They have, you're right, been strengthened over successive years, and also in response to, I worked on the response to the Victoria Clambier inquiry. There was a big point of strengthening, and a number of similar issues in terms of information sharing came up then. They will bring education expertise into the discussion in a way that they haven't been to date, ensuring that education is represented in some way on these multi-agency partnerships. Both the information sharing and the multi-agency working does exist, but the bill is seeking to strengthen the arrangements and give them greater prominence and importance.
You tell us in paragraph 194, it's page 51, please, Sarah, that the Children's Wellbeing in Schools Bill will introduce a provision to enable the specification of an SUI, a single unique identifier for children in education. Is that right, first of all?
Yes, that's right.
How is that going to help in appropriate information sharing?
I think it helps, but it doesn't solve the whole problem. So there's two issues. There's culture and people, and there's a mechanism and a process, and this is the latter. So it will be helpful because it will allow different systems to speak to each other. It will join data up. What it won't solve is people needing to input the right data and share them and have discussions and talk to each other and clarify information. And just what you were asking me about before lunch, the feedback mechanism between schools and Prevent, it won't solve that. So that's why we're trying to do more and both things.
Obviously, information sharing is important in the area of safeguarding risks of people doing harm to children and risks of children doing harm to themselves. But I obviously want to focus for this inquiry's purposes on the risk from children to harm to others. For the cohort of children in this sphere who either it's not a Prevent type issue or they're referred to Prevent for violence issues but are not taken on. The challenge perhaps is this: even with the strengthening of this bill, are these sort of multi-agency arrangements really fit for purpose? Given the perennial difficulties that have been encountered, are they in fact ever going to meet the requirement for effective management of children's risks to others, where the risk is of causing death or very serious harm?
So a bit of the work and thinking that I've done on violence fixated individuals, I think has flagged not the problem with people getting together to talk, but knowing whose responsibility it is and what to do. So I think the measures in the bill will help to bring people together. I think the question that is more difficult, and I don't know the answer, and I'm sure it's also part of what you're trying to find out and make recommendations about, is what happens when an individual system partner's intervention isn't deemed to be the right one for the individual. What happens when they fall out of everybody's intervention thresholds or offers? Actually, what more do we need to know about what interventions are successful, for what risks and issues, and to make sure that there is either a backstop or more collective responsibility when people don't fit into the individual silos. So I'm sure that's part of your questioning and thinking. It's also part of the work that we're trying to do to work out who catches, where does the responsibility sit, and what critically are the evidence-based interventions that help. And I don't think we have the answers yet.
So if we look at page 68, it's the very last part of your paragraph 268. You refer there to, just allow it to come up on screen, to being aware that the Home Office is currently piloting a more structured approach to cases not suitable for Prevent, but with demonstrable high risks, and anticipated learning from this pilot to inform our support to the education sector on such instances. Where has that reached?
So it's still learning and is still a work in progress. I think there's 2 points to make. One is trialling of cases and individuals that have been flagged as risks, and that's good to work those through the system. I think the other sort of systemic question is, in the majority, our individual systems are set up, certainly the ones I know most about, the education and childcare systems, are set up with the response being risk to individual rather than risk from individual. Yes. And that is the piece of work that we've been doing across government to both better understand each other's systems, but also take some examples to work them through the system. So I don't know, but I have, and my department has a reasonable degree of confidence that the individuals who are a risk to others are probably already in some intervention in the system, either in education or children's social care. But working through the individual cases of those will give us more information about whether that's right to be confident about or wrong, and what we would need to do.
Which agency has the lead responsibility for those cases if they're not taken on by Prevent?
So the local authority has the backstop duty around duty to safeguard, and I think the police have the security duty of populations and communities.
Is one agency clearly in the lead or not?
I don't think so, no.
Is that itself a problem?
Yes.
Has thought been given, because of the difficulties of information sharing, despite government attempts to encourage it and not to see GDPR as a barrier, has consideration been given in this area to a board such as MAPPA having to be established so that there is a structure to bring it together rather than to rely on individual agencies, so that there's greater formality to it and a clear board?
Yes, the work that we've been doing has been looking at the different kinds of structures that exist in different areas. They're not always the same, and they don't always meet in the same format or regularity. So we've looked at the multi-agency safeguarding hubs, we've looked at the duties in the bill about multi-agency protection teams, we've considered mappers. The piece of work hasn't finished, and I think what we've discovered is different places operate in slightly different ways. I suppose the other bit that is worth saying, probably well known and has probably been said by other people, is mandating a structure doesn't always guarantee the relationships are good. So there's something about the culture behind that that is important as well.
So having a structure in place doesn't guarantee good practice or that the culture is right, but it certainly requires consideration. Would you agree?
Yes, it does, yes.
If the current position is the lead agency isn't clear.
Yeah, well, lead agencies have different leads for different things, don't they? That's part of the issue.
Paragraph 455 of your statement, please. You mention the MASH. And in paragraph 455, you say that post Lord Anderson's report, you indicate that work has been done on the front door approach to multi-agency safeguarding hubs, the MASH. Again, for cases that involve risk to others, at the moment, is the MASH approach working? Isn't it more focused on the risks to the child?
That is how it has been set up. I think what I was trying to explain was we feel reasonably confident that those individuals are probably being picked up in one way or another by the system without having finished the piece of work that follows all of those through to see if that is the case. I can't be sure. But if we consider the kinds of interventions that would be offered through those different systems, they are often fairly similar interventions. So attending school is a massive protective factor. Having some sort of engagement or belonging to something if school isn't either working for that individual or isn't giving that sense of belonging. We might come on to talk about the after-school setting sector, but that can often be an intervention. Various other interventions, obviously children's social care is an intervention at different levels. There are police and custodial and criminal interventions, mental health interventions, all sorts of different ones. I think we feel like those interventions probably are the right interventions, and probably individuals who are risks to others are in contact with the system somehow. But to do the piece of work to see if that is the case by mapping a lot of case studies, and then seeing whether it is the joining up of services or the absence of any service that's a gap.
There's also a risk of inconsistent treatment if they might be dealt with by different agencies in different ways, because your evidence is really, we think they're probably being picked up somewhere in the system, but it may be picked up in different ways. but overall we think the interventions are probably along the right lines.
Yes, I agree with the think is definitely the risk that needs to, we need to be sure. In terms of the inconsistency point, yes, probably, but probably appropriately. If the system is picking up the right people and giving them interventions that work, it doesn't matter that it is inconsistent because every individual is different, and probably as long as the ideal is that the system is working to give the appropriate oversight, intervention, catch the individual and give them what they need rather than needs to be the same everywhere.
Does the mounting evidence in AR's case not dent that sense of confidence that you have that the right interventions are probably being done?
It does dent my confidence, yes. I think it's very clear that he was offered different interventions because that's what the different services had available, and he did or didn't meet the threshold, but also that they didn't succeed, did they? I suppose the other point, which I was going to save to the end, but is the point about voluntary engagement. So the vast majority of those interventions require some sort of cooperation or voluntary input of the individual. Even if they're the right ones, they will only work if the individual wants to engage until you get to a criminal line.
All right. At an important, potentially stage in the chronology of agencies dealing with AR, you'll be aware that there was an incident where he was found on a bus with a knife.
Yes.
Saying that saying to the police that he had the knife because he intended to stab someone, and referring to the police officer to poison, either having had thoughts of poison or possibly having tried to make poison. If we could have on screen PRE 30357. At page 2, Sarah. If we look at the bottom email, the Op Encompass referral had actually meant that Acorn School were alerted to this incident, but they had been trying to find out more, both from AR's father and from Cam's, in part because they were conscious that although AR wasn't attending Acorn's school by this stage because of the poor attendance, that they felt an obligation to understand the risks, but also to pass them on to Pressfield School, to which AR was later going to be attending. And Miss Allred, as you can see here, emailed CAMS saying, can you let us know how the meeting with AR went on Friday and clarify what were the issues that caused AR to act the way he did on Thursday? So that's a reference to going missing. Please give as much information as possible so we can update our safeguarding and risk assessments. It would also be useful if you can liaise with Pressfield School. Are you happy for me to forward your details to them? Now that reference to so that we can update our safeguarding and risk assessments, there couldn't be, would you agree, a clearer indication that this was necessary information, because this was AR's school making the request to be put in the picture about what they needed to know about risk information. Yes?
Yes.
And if we go to the top of the page, notwithstanding that on the evidence it seems that they did have information about the incident on the 17th, the response from CAMS was, good morning, Maggie. AR came to session and engaged well. From what he shared, I can let you know that he does not want to return to Acorns to say goodbye. So on the face of it, what the chair will have to consider is whether it was a deliberate withholding of risk information on the basis that, on the face of this, perhaps he wasn't going to come back to that school. Your view of that?
And this is from health. I think it speaks a bit to the point we were talking about, the duty to share for safeguarding purposes, overriding confidentiality reasons. So there are cultural differences probably between agencies about how much they share, and I'm not talking from my expertise, I'm talking from broadly what I know in life. I think health holds some information as private, but I think what we're talking about, and in our changes in our bill, we are seeking to make it clearer that the duty of safeguarding overrides those concerns.
Yeah.
It's similar. I work across the not just the prevent but the contest space in the Home Office. Actually, quite often the challenges of our different agencies working together do come quite quickly up against the different cultural expectations around sharing information. And that's more on a security side than a health side, but I imagine it's a similar culture.
While one speaks about cultural understandings, and of course everyone will have some experience of what you mean about healthcare information received in confidence and an understandable reluctance to share patient information unless it's appropriate. Where the information is that a youth has been found with a knife, and that request is coming from the school to the mental health services, that is a plain breach of the duty to share risk information, isn't it? It's not cultural, it's just getting it really badly wrong.
I mean, obviously it would be better that the information was shared. I don't know all the ins and outs of whether there was any restrictions on the police information, and whether that health felt that wasn't their information to share.
Well, I understand that. In a sense, there wasn't a restriction on the police information because through a different route, the police had already shared the information. I take this email as an example, but it does illustrate the size of the challenge. Would you agree?
Yes, I think it does.
Thank you. Could we turn next, please, to the different subject of guidance for out-of-school settings. And in paragraph 388, page 99, you helpfully set out, it'll come up on screen in a moment, but you helpfully set out that the department is the central government department that has the policy responsibility for safeguarding in out-of-school settings, yes? So DFE 30256, please, Sarah. 388. So this comes within your area of responsibility.
It does, yes.
Yeah. We see from 389, a little lower down the page, that in overview you say that the out-of-school setting sector is large, broad and diverse sector, which is unregulated under education and childcare law. Is that right?
Yes, that's right.
And the definition includes commercial and charitable or individuals who are providing tuition, training, instruction or activities to children in England without the parents' or carers' supervisions, but then are not schools, colleges and so on. So it's almost a definition by exclusion. It's everybody else.
It is, yes.
Who's providing that. And there would be great variation within that from one-off children's events through to classes that take place inside, to outdoor activities, outdoor pursuits, matters of that kind. Would you agree?
That's right. It's a very broad and varied sector. Your
statement explains that there was guidance published, first published, I think, in October 2020 under the title of Out-of-School Settings Safeguarding Guidance for Providers in October 2020. Had there been some earlier guidance before the 2020 guidance with a different type of title?
I don't believe so, no.
And then it was updated in September 2023, and a further version was published at that time. If we look at 392, taking the helpful summary from your statement, you say that 392, page 100, please, Sarah, middle of the page. It's aimed at helping OOSS providers to run safe settings and ensure the welfare of children, sets out the policies and procedures that you would expect to have in place to meet their legal duty of care. And it also helps them to understand, because it makes clear legal requirements that they may need to meet under different legislation, for example, Safety at Work Act and the regulatory reform fire safety orders. Yes?
Yes.
Thank you. Since the Southport attack, so just for your note, it's paragraph 408. I think there's e-learning has also subsequently been published. Is that right? May of this year?
Yes, it has been published.
So if we could look at the version that was contemporaneous at the time, it's DFE 30254. DFE 30254. And if we could go to page 34. There's one aspect of this that I'd like to pick up with you, but it involves going to a couple of different pages. So we can see here you're responsible for health and safety regardless of your setting, whether it's for a classroom, youth centre and so on. And as a minimum, you should annually review and update your risk assessments, treating them as living documents. You should have active arrangements in place to monitor whether your controls for managing risks are effective and working as planned. You should also have an emergency plan in place to help you and any staff respond effectively to an emergency. Then it says all providers must have a fire safety and evacuation plan. So that seems to be risk assessments, an emergency plan, and a fire safety and evacuation plan. Would you agree?
Yes.
If you go to page 35, it makes clear that if you are top of the page, a provider with 5 or more staff, then you need to have a written health and safety policy, including a risk assessment section. Yes?
Yes.
If we go to page 36, we see that a section headed, if you have fewer than 5 employees. Can that just be highlighted, the bottom section, please, Sarah? If you have fewer than 5 employees, you do not have to write down your health and safety policy. And that gives an example. And then it says, we would expect you to have assessed the health and safety risks, keep a first aid kit in your home, know what to do in case of emergency, be able to explain to parents the steps you've taken to reduce the health and safety risks. So for small providers, of which the dance class involved here would have been one, do you see that reference to emergency plan and a fire safety evacuation plan seems to have been elided into know what to do in case of emergency?
Yes.
Would you agree that that could be clearer if there was an expectation that they should have an emergency plan and a separate assessment for fire safety and an evacuation plan, that could have been made clearer in this guidance?
Yes.
And then at page 37, an example is given, and what's said there is that there's a suggestion about writing their own risk assessment. But again, would you agree that it doesn't go on to specify any duty to write or specifically address an emergency plan? Just take a moment to read it. So under our advice, still carry out her own risk assessment, even though the hall owners have got a generic one.
Yes, the fire risk and the case of emergency is all in one line.
Yeah.
Yeah.
So again, if the intention of this was to have a requirement for an emergency plan, do you see how a small provider may not have picked that up, even trying to follow this guidance?
Yes, I do. Yeah.
Yeah. And over the page, on page 38, it makes clear that there's a requirement for a fire safety management policy and evacuation plan. So that's the sense of the fire-related evacuation plan, which we've seen earlier. But again, no reference then to what we saw earlier on about some concept of an emergency plan that was separate from a fire safety and evacuation plan. Would you agree?
Yes.
So there is, within that guidance that was issued at the time, would you agree, especially for small providers, different terms being used not perhaps as clearly as they could have been?
Yeah.
What is apparent, and I won't go through it to prove the negative, but what's apparent is that there was no specific guidance on protective security. So there was nothing about locked doors, keypads, video phone entry, intercoms, magnetic lock release doors. Do you know why that was? Was that deliberate?
Yes. We've talked about this sector being very large and varied. The voluntary codes that we put together were seeking to increase the awareness and responsiveness of out-of-school settings, but without the backing of the statutory legislative duty or regulation behind it. A set of best practice. Schools have quite a detailed piece of guidance around school security and premises security. The out-of-school sector is made up, as you said, of very small providers through to very big providers. And in our approach to the question that we're asking ourselves of regulation, we're trying to seek a proportionate approach that ensures we don't stifle that sector, but encourages providers to think about the safety, amongst many other things that they think about of the setting and also the personnel that are involved. I think about 1 in 10 adults are volunteering with an out-of-school setting. It's a big workforce and one that relies on voluntary contributions. So it doesn't have as many sets of rules around it, and I think, as has been seen in some of the evidence so far, the expectation of the risk has been far more on the fire side. Or, for example, we ran some pilots around out-of-school settings when we were trying to work out what the next approach should be in 2016 about regulation of the sector, and the risks that came through that were not in the protective security space. They were more about people, abuse risks and things like that.
Yeah.
I can stop, or I can tell you about the call for evidence if you would like.
All right. I'm going to come back to the issues that you raised, but another factor that we see is absent from this guidance in the 23 version is any reference to supervisory ratios for adults to children. And the inquiry has seen that there is some best practice guidance from the NSPCC suggesting that there should be 2 adults present and 1 adult to 6 children, where those children are aged between 4 and 8 years old. Now that's that organisation's recommendation or guidance, but neither that suggestion nor any other guidance as to ratios appears in the September 23 OOSS guidance. Again, was there a reason for that? Is it the same thing?
It is the same thing, and it was thought about, but on the proportionality balance, we decided against ratios.
So you've referred to the 2015-2016 exercise, and I'm just going to see if I can summarise it in this way. I think there was a call for evidence that looked at current practice and whether there should be introduced a system of regulation of the settings. Is that right?
Yes, that's right.
And the government response to that, in the end, was that there shouldn't be regulation of the OOSS area. But what there was a focus on giving the local authorities information and the powers and encouragement to monitor and take action against poor providers who were poor at safeguarding.
Nearly, I suppose. So the government decided not to regulate at that time, didn't rule it out completely, and then set up some pilots to try and work out in some local areas whether the existing powers that were across different bodies, so for example that would include the health and safety, the fire, but it also included, for example, powers of the Charity Commission. The pilots sought to try and find out what the gap was.
Yeah. And what was the result?
The result was that there wasn't a clear consensus on what the gap was. It wasn't clear what the way forward was. As I mentioned, quite a lot of the risks that came up there were around people risks, so physical or sexual abuse risks rather than premises risks. However, I don't think we or anyone think we have cracked the problem, so we are again running a call for evidence. It's quite...
All right.
Okay.
But I'm going to come on to that.
Fine.
But at the time, what changed as a result of that exercise in 2015, 2016? A call for evidence, a decision against regulation at that stage, not completely ruled out. I think we've seen reference in your evidence to an emphasis on those organisations that might have poor safeguarding and my words, cracking down on them. Was that one thing that did arise from that?
Yes, in terms of using the powers that already existed.
Yeah. And then on to the current call for evidence. So you started to talk about that. There's been a DFE publication call for evidence. DFE 4084 is the reference. We needn't bring it up. And I think the deadline for responses has been pushed back a month. Is that right?
Yes, it's now closed, though.
It's now closed.
Yep.
21st of September was, I think, the pushback date. Now, Ms Dixon, for the purposes of the questions that follow, could we try to separate out the question of formal regulation as to whether there should be a regulated sector and the potentially different aspect of whether there might be some best practice guidance or at least guidance, even if it doesn't amount to regulation? In the area of security provision, appreciating that some of the settings will be outdoors, sports instruction outside, and other outdoors activities. Looking at provision for children's classes that are indoors, what's the department's current thinking, if it has a view on this, as to whether there should now be introduced some sort of guidance, perhaps short of regulation, but giving guidance as to the desirability of, for example, magnetic locked doors rather than open doors that still allow you to get out in the case of fire, but don't allow you in from the outside. Does the department think that some guidance might or should be published in that area? Can you help?
Yes, I can help. I think, obviously, we've not taken a proposal to ministers, so this is not with ministerial decision involved in it. I suspect, though, the mandating of anything in this sector won't happen unless it's done by sort of proportionality of activity of risk. So I don't think that we would be mandating or highly recommending magnetic doors or
And in
or
what
such.
circumstances might it come into play on proportionality based on risk and size?
My point would be if it aligned with, say, the Martin's Law regulations around size of venue or number of people, or perhaps if you try and segment the out-of-school setting sector into different kinds of activities, then that might more likely follow the risks that we saw in the pilots, or it might be, for example, overnight activities were more risky than those that were taking place in the day, or extreme sports activities might require a different set of expectations than those that didn't have such high activity risk. On the point of magnetic doors and security, I can see in this very tragic case why that might come into question. I think what we're seeking to balance is the diversity of the sector and the availability of it. So actually, if we put those sorts of rules in place, I think it would be highly likely that a number of activities and providers, a large proportion of them, would not continue to offer services or carry on, which I think the balance for us would be around available opportunities for children and young people versus absolutely secure, 100% safety.
Given the potential widespread benefit of small local providers, is there a case for funding being made available on a grant basis to improve security? You say there'd be a concern that mandating it or encouraging it would mean that providers would disappear. Of course, one understands funding pressures, but isn't there a case, given the benefit?
I think it's unlikely. I did have one idea, however, which was in the same way that we've used, a number of different principles in the voluntary code guidance, both for providers and for parents, and for local authorities, whether there was, and we've used the basis of other documents where there is a mandatory responsibility, whether actually there was anything we could do from the protective security guidance to schools that we could include a paragraph or two in the voluntary sector code to give some more ideas or examples of the sorts of considerations. That's in no way saying you need to have magnetic doors, but actually it might make a difference in choosing your community venue when you were picking between the two, if that was what the provider thought was an appropriate response to that risk.
It's a hugely sensitive issue in this inquiry, because on the one hand, for some of the victims, they look at AR's access to the venue and feel that there should be change. At the same time, for other victims, that there wasn't any guidance in place at the time. The fire escape routes had to be kept clear, and there may be a concern that it might have been even worse if there had been even magnetic lock doors. But in part, bearing in mind the intensity of those sensitivities arising in this inquiry, Would you agree that anything that can be done, even if it's by way of, for example, consider what is provided in schools, and pointing the way to options, would be better than the current being blunt silence in the guidance? Would you agree?
Yes, and I think that's what I was offering.
Thank you. One moment. Chapter 6, Ms. Dixon, of your statement provides reflections and some indications about areas of potential recommendations. I've touched on those that I think are more central. Is there anything that you wanted to add?
I think you have covered all the things I think I wanted to say. I guess two additional thoughts. I think part of the changes in my role have most recently been trying to bring together some of these high harm risks to individuals and where they're at risk to others, and have my role facing the Home Office to improve the ways that we work together, both in the Homeland Security Group, which is the prevent contest bit, but also in the Public Safety Group, where violence, knife crime, violence against women and girls, misogyny is taking place. So I definitely take the reading that I've done and the questions that you've asked me back into that role. Then I think the other is I don't know if you've talked to the youth offending team yet, but I think there might be something for me to take back into the role around sort of violence fixation and individual risk to others, around the voluntary nature of interventions and youth diversion activity. So that's definitely given me a bit of a thought, and I will follow your evidence on that and see if there's something that I can think about in advance.
Thank you.
I think that's all.
I'm just going to turn to my left and see if anybody other than Mr. Bowen has questions. No. So may I indicate in relation to Mr. Bowen that questioning pro-forma was completed in relation to certain topics. And on this occasion, some questions were posed about social care thresholds, and permission was refused on the grounds that there are witnesses to come who are better placed. My friend Mr. Bowen, with his usual courtesy, has asked if I would ask those, and I've declined because I'm not sure that they are for this witness. But I think Mr. Bowen wishes to ask the question, so we're in your hands. It may be that it would be helpful to see what the questions are and see how the witness is placed and whether she feels she's able to do them, but that's the position we've reached.
Yes, Mr. Bowen, I'm very reluctant to have a witness who isn't well placed being asked questions, who's then going to be followed by a witness who is well placed to answer the questions. So if you want to start, do, but anticipate an intervention by me fairly early on if the answers aren't as satisfactory as one would like them to be.
I would entirely agree with that, sir, but I have a fundamental issue, which is that whilst Mr. Moss, in his response to my Rule 10, accepted the interaction between education and social care, it's become very clear listening to this witness, and I confess, looking again at keeping children safe in education, that there are long sections in that guidance which is directly the expertise of this witness. So I want to ask it from the perspective of the educationalists, not Lancashire County Council, who, of course, one of the things that they will be justifying is that they didn't carry out a Section 47.
All right, I understand.
So that's the point.
Right, I understand that. But I will be very much against doing this twice with two witnesses. So
I agree.
you have got choose your terrain and live with the risk that goes with that.
I agree, but this, from the perspective of the bereaved families,
right.
is fundamentally important, sir.
Fine,
So
but
I would ask for a little latitude.
I will give you a little
I'm
latitude,
grateful.
but I don't want excessive duplication.
No, I'm grateful, and I will be as quick as I can. It's a huge document, keeping children safe in education. You obviously didn't write it, but you're in charge of its continuing development and are familiar with its content.
Yes, reasonably so.
Okay. Just for your notes, the particular paragraphs of the guidance, 14, 60 to 61 and 62. And that's where, we don't necessarily even need to...
That's fine, I'm just writing it down in case there's something for me to take away.
Yeah. I mean, I can give you the reference numbers, sir. 14 is DFE, I think 4019, page 9. 60 to 61 is page 19, and 19 to 20, that's 60 to 62.
Thank you.
Let me just put a little context into why I'm asking you this question. I don't know whether you were here when you heard the evidence from Mrs. Hodson.
From Acorns, yes.
From Acorns, yeah.
Yes.
And she talked in terms of her reluctance ever to pass the risk on by way of permanent exclusion.
Yes.
That she was very, very clear on the extreme safeguarding risk as she saw it, almost from the beginning of her involvement in the case. Now, what we know, and I'm not asking you here to adjudicate upon the correctness or otherwise of what the local authority did, okay? We know they didn't carry out ultimately a Section 47 because at all periods they didn't think, I would say bizarrely, that the threshold for significant harm was not met, okay? Mm-hmm. So that's the background. So you've got this teacher holding the baby, as she put it.
Yep. What
does she do? We know what she says she can't do, exclude. From the perspective, given what it says in those paragraphs, which is essentially explaining how the system works in terms of what Section 17 is, i.e., you support the child with services under Schedule 1 to the Children Act, if he or she is going to suffer harm. But if a child either is suffering significant harm, which we know here is the case with AR because he's out of school, that in itself arguably is significant harm, what is the educationalist, if anything, given the content of those paragraphs which explains the process and the difference between 17 and 47, what is the teacher or the senior leadership team supposed to do instead of just continuing to hold the baby and sort of just hoping that nothing awful happens?
Those two things are referenced in Keeping Children Safe in Education, but they're referencing other children's social care documents. I don't necessarily think that being out of school meets the threshold of Section 47.
Okay.
I would imagine there were different factors and other factors that would meet the Section 47 threshold, which there may have been or may not have been, but I wouldn't rely on just being out of school being one of them. I think that though the local authority has the ultimate duty of safeguarding and promotion of welfare, so the overriding duty in safeguarding terms does rest with the local authority. I think, as I said before, I think Acorns did do a very good job of trying to find lots of different ways to engage AR and offer him through education and their pastoral care support. and applaud them for that. There were lots of other agencies involved in trying to offer appropriate interventions, and I think the local authority has acknowledged its role in the backstop and not meeting that.
It's my fault. I'm not asking for a justification for what they did or didn't do.
Yeah.
Right. And just assume, for the purpose of my question, that there is a situation where a child is suffering significant harm.
Yeah.
All right. Which, reading between the lines, is pretty much what Mrs. Hodson was thinking. Is there literally nothing apart from permanent exclusion that they can do? Because I have an idea I'd like to put to you.
Okay.
But, all right.
Well, why don't you put your idea?
I will. I was just giving her a chance to see whether she had one as well. They could just formally request that the guidance there in keeping safe for those paragraphs in the guidance, that they actually write saying, we believe we have a child who we are very reluctant to permanently exclude, is either themselves suffering significant harm or is in danger of causing somebody else significant harm. Why are you not carrying out a section 47 assessment, of what they used to call a core assessment? Because if you don't, we are going to give you back the baby. We are going to exclude this child, which is wholly against everybody's interests, but you are not doing what you should do. Now, I know that's a huge ask for an educationalist, but should there be something in the guidance to deal with this problem?
I guess 2 points to make on that. One, there was nothing to stop Acorns making a safeguarding referral back to the local authority, and I think in many ways they felt like they were highlighting that risk. I don't know whether they did anything more formal, as if they were just a member of the public putting in a safeguarding referral. To your point about permanent exclusion, my reading is that they probably could have done that, but they didn't want to because they didn't see what the alternative was. I think she said something like, "I just don't know where he would go."
But that's not her problem, is it? Ultimately, that's the local authority's problem.
It wasn't her problem, but she was bigger than that.
Well,
wasn't she?
Exactly. But what the inquiry is doing is looking beyond at what teachers should do in those circumstances when considering a social care question, because inevitably, we're not in silos here, they interact.
Well, they should refer it a social care problem to the social care people, which is the local authority, no?
So there should be no reluctance. They shouldn't be shy in really bashing the ball back to a local authority.
Well, I think there's a difference between making a referral and extricating yourself from the problem, isn't there?
I think you have your answer, Mr. Byrne.
Very well. There's one other tiny point, and this is in my Rule 10, and it's this. At paragraph 187, there's a reference to rapid reviews. And you explain a little about the problems with sharing information, presumably.
Oh, yes.
And why the local safeguarding partnership objected to sharing their rapid review beyond the DFE and the Secretary of State. Can you tell us a little more about that?
I can't tell you all the ins and outs, but what I can tell you is that was a problem, and we did get over it in the end, and we have made changes going forward to make sure that is more freely shareable.
And is that rapid review available to the inquiry?
I don't know, I'm afraid. Sorry. I can find out probably. But if you haven't got it, it probably isn't. But I can find that out for sure.
Because it would be good to see it. I mean, is it within your power to provide a copy?
It's not mine. So this is Children's Social Care, and it is the panels, I believe. So no, it's not within my gift.
I'm almost done. So one last one. Are you able to tell us whether the reluctance to share that information was all about reputation salving and covering their backs?
I can't tell you, sorry, I don't know.
Okay, thank you. I'm very grateful for you allowing me to answer those questions, because I am in fact in breach of one of your protocols. We should have given notice, and I apologise for that.
Thank you for the confession, Mr. Byrne.
AHCH 30165 is the rapid review.
Thank you.
Yes, it's actually in the statement. You have outlined quite a lot of work that's going on at the moment.
Yes.
That there's been calls for evidence, there are bills going through Parliament, there's a variety of different pieces of work which are going on in response to what happened on July the 29th last year. One concern I have is that we will do our work, and that we're going to be writing at speed once the hearings finish at the end of next week. You're going to be doing your work, and there's going to be a complete lack of synchronicity between the two. And I think it would be unhelpful to ministers for them to receive one set of recommendations from me and an entirely different set of recommendations from you,
Yes.
when neither of us know in what direction our thoughts are going. Now, what do we do about that?
Talk.
Indeed, I would quite like to know at what speed you
Yeah.
anticipate travelling, so that I can have some idea as to when you are at the very least going to be able to share a good idea of your direction of travel, subject of course to ministerial approval, before my recommendations get anywhere close to being put before the Home Secretary.
Thank you. Yes, I was anticipating this problem too. I don't know whether you have already thought whether you're going to give recommendations after phase one, but if you are, then I suspect you will be quicker than a number of the things that I've talked about. So, for example, the out-of-schools settings call for evidence. I imagine you'll get to your recommendations at the end of phase one quicker than I will get to ministers with mine. The bill is probably fairly straightforward. The violence fixated individuals work, I will give you the best update that I can, but that has, I don't think is, I think you'll move faster than we will on that. I guess really happy to share as much as possible. If you think you're going to give recommendations at the end of phase one, perhaps we ought to have another, are we allowed to meet?
We are.
Yeah, we should have another meeting.
Yes, I'm just taking the example of violence-fixated individuals. That is, for the most obvious reasons, an area of particular concern to me. And I would be very reluctant indeed to come up with a set of recommendations for at the end of phase one. And at the moment, that is something that I would like to do.
Okay.
At least to make solid recommendations as to what needs to go into phase two.
Yes.
But I would be against doing that if you're doing a parallel piece of work and I do not know where you're heading with that.
Yep.
Well, it may not be that now may not be the right time to come to any firm conclusions about this, but I'm going to ask you and those who are advising you to go away and think about this.
Thank you.
So that we can do this in a structured way, which means that the outcome of this inquiry is of the greatest possible assistance to the Home Secretary.
Thank you. That would be very welcome.
I'm very grateful for your long statement and
you.
for your evidence today.
Thank you very
You're
much.
now free to go.
Thank you
very much.
Thank you. Thank you very much, everyone.
So thank you. May I deal, please, with some procedural matters?
Yes,
at this
certainly.
stage? So we've come effectively to the end of the education evidence, and with two exceptions, we've also reached the end of the evidence in relation to mental health and psychiatry. there are two presentations from counsel to the inquiry, one in each of those areas. So given the pressure on the timetable today, we would propose to seek to deal with those probably on Wednesday, possibly with a 9:30 start, but not today. The update I should indicate in relation to the evidence on mental health and psychiatry is this. So first of all, there is still possibly the evidence of Dr. Imran to come. You remember who was the co-author of the statement with Ms. Brown. It may be that we can deal with that matter satisfactorily by written evidence, and there is a process of consulting the court participants about that. But there is still some potential for evidence for her. The second exception to the evidence on psychiatry and mental health being closed is this, that as you know, last week at an appropriate venue, my own friend Ms. Wakeman, as junior counsel to the inquiry, conducted a pre-recorded interview with Ms. Morris. We hope to be in a position to circulate that to court participants in the accredited media. We may be able to do that today, but certainly the early part of this week. So that was done because she was not fit to give evidence in public in the usual way. So all of that has been done and is in hand. So we turn next in the inquiry's themes and topics to deal with the social care evidence. But there's an important procedural matter here which I need to put on the record. Last week, in the lead up to the social care evidence from the County Council and the witnesses that we'll be hearing from this week, there were various incidences of additional disclosure from the County Council. While late, these were not unduly concerning in the context of a fast-moving inquiry, and the material, for the most part, was not specific to AR. Much of it was after the event. However, starting on Thursday of last week, matters became more concerning. My own friend Mr. Goss, as junior counsel to the inquiry, in the course of preparations for this week, noticed that the statement of Miss Ashworth contained detailed references to, in one instance, WhatsApp messages, and in the second, separate text messages from Alfonso that were not in the Lancashire County Council chronology and were not in the disclosed care notes either. He emailed leading counsel for the County Council, and that set in train inquiries which revealed that both the social care notes and the early help records for AR that have been disclosed to the inquiry are incomplete. It seems that Miss Ashworth was working off her own printed bundle of records, which was more extensive than the records that had been disclosed to the inquiry. So, as you know, this was communicated to the inquiry legal team during the course of Friday morning. As a result, with your guidance and supervision, sir, the inquiry legal team required that a signed disclosure statement be provided by 4:30 p.m. on Saturday. That statement, signed by Heloise McAndrew, Director of Law and Governance at Lancashire County Council, was received on Saturday within the time frame and has been disclosed. Could we just have it on screen, please? It's LCC 202303. So I just bring that up. I'm not going to go through it, but I bring it up so that its correct reference is known. Ms. McAndrew, together with the Chief Executive of the local authority, attend today. In the statement, Ms. McAndrew acknowledges on behalf of the Council that this is a serious failing, and it is one which she says she has personally investigated in order to understand what has occurred and why. The working hypothesis that's set out in this statement is that because the records have been locked down for security reasons in the aftermath of the attack, security clearances had to be issued to enable the data records team to access the records in order to provide copies to the authority's legal team. And in authorising their access to these records, the Data Records Service has been given authorised access to AR's records and later to DNR's records without being made aware that their parents were also associates on the Liquid Logic system. So that's the software regulating, as we understand it, the notes. As is set out in this statement, the apparent impact of this was that when the records came to be exported from the system, and we were told in August 24, April 25, and May 25, they did not capture all the associated entries linked to AR's parents in the recording. So that's the working hypothesis that has been set out as to why the disclosure was incomplete. From an update that was received yesterday evening and from further communication received today, sir, we understand that this remains a working hypothesis, but the ongoing work that's been done, has to be said in fairness to the legal team involved urgently over the weekend, is tending, as I understand it, increasingly to suggest that this working hypothesis is correct, and as we understand it, that effectively permissions in relation to records linked to the parents were set in a way that meant that they didn't get captured when the records were put together. So there are, however, a number of concerns which I need to place on record. The first is that the original explanation that this was an artifact of records that were produced in August 24, April 25 and May 25 seems odd, given that the only version of the records the inquiry is aware of is the August 24 version of the records. From the update that was received last night, it appears to indicate that whilst further searches of AR's social care records were undertaken in April 25 and of DR's records in May 25, the authority has now established that no additional requests were made for the original Liquid Logic records at that time. So that may suggest that we are just dealing with one set of records dated August 24. But so we need still to be clear about exactly what searches were done at each stage and why it is that the incompleteness was not spotted at those different stages. Second, the corollary of the Council's explanation is that the records that have been provided to the inquiry were the same that were provided to Merseyside Police for their criminal investigation, and therefore that the information provided for the criminal investigation to the police was also incomplete. So whilst our own preliminary assessment is that the missing material does not change the overall picture on, for example, the lack of any clear terrorist ideology, the missing material would in part, we think, perhaps have been of interest to the prosecution. So that magnifies the sense of concern that the correct records have not been disclosed, or that the records, I should say, are incomplete. Thirdly, there is the fact that one of the witnesses, and a senior one in Miss Ashworth, did have access to this material, was referring to it in an interview providing her witness evidence, yet that was not picked up either by her or by the local authority, the council, or, it seems, by the legal representatives acting for them. Fourthly, the omissions are extensive, assisted, again, diligently over the weekend by the legal teams concerned. We have seen unredacted versions of both sets of complete notes, with highlighting to show what is new. We are not speaking here of only one or two omissions. They are extensive and run to a number of pages. Fifthly, while some of the new material reflects what is on other records, so it is effectively Lancashire County Council's version of meetings that were attended by others, such as Acorns, CAMS, FCAMS, the schools, and some of them do reflect meetings that we're aware of already. Others are entirely new and significant. Let me give one example. There's a reference to a home visit by Ms. Lewis on the 4th of October that reads in part as follows, quote, parents signed registration form. They asked about consent and what it meant. Worker explained that CFW work with various agencies and signing the form will allow information to be shared with agencies to identify correct support for them as a family. This prompted AR to share his opinion on consent and information sharing and felt that anybody can access his information, and he didn't want this. It was explained that only CFW can access any information on the system, but information can be shared with other agencies if there are concerns. He went on to say that MI5 and MI6 can access this if they want. This led on to him beginning to be vocal on politics, American government, and Taliban. So it's a record that we've not seen before, that AR was vocal in his interest in MI5, MI6, and political issues around the US government and the Taliban, is of obvious relevance. And we would have wished to have raised that with previous witnesses dealing with Prevent to see if that information would have made any difference, for example. Sixthly, as a matter of concern, while these records do raise issues for forthcoming witnesses starting this afternoon, the material is also relevant to AR's parents, and the inquiry legal team has not been able to include this material in the detailed request for statements that went to AR's family members, and they've not had a chance to address it, so it's disruptive in that way. Seventhly, sir, while the impact is obviously greatest on others, we do note that this has an impact on the County Council's own witnesses who are about to give evidence. In places, there are issues about poor record keeping, notes of meetings not being made. And while some of those issues remain, part of the reason why witnesses have been saying, well, I think there should have been a note of this meeting, but I can't explain why there isn't one, is that there was in fact one, but their own employer had not disclosed it properly. Eighthly, it's a matter of concern that this matter has only come to light because of the forensic analysis done by my learned friend Mr. Goss in preparing work for witnesses this week. If he had not asked the question, these records, we are concerned, would never have come to light. Ninthly, there is the disruption to the inquiry, which is considerable. We have done our best to redact this information. Some of it was circulated yesterday and more this morning, so we have managed to get it around. But it has been a considerable disruption to the inquiry team in terms of our preparations for this week. But so in a sense, that does not matter so much. At the forefront of our minds is the other core participants, and most especially, of course, the victims and their legal teams. It is a disservice to them that the disclosure hitherto from the local authority has been materially incomplete, we suggest. So these are serious matters. On the evidence and explanations given, there does not appear to be any basis to consider that this material has been withheld in bad faith, and we make that clear. But we are concerned that this is a serious and significant disclosure error, which is suggestive of a failure in the duty to ensure that the material disclosed to the inquiry is full and complete. So I merely note, other than putting these important matters on record, that the explanation and investigations are not yet complete and they are ongoing. We have had full cooperation from the local authorities' legal team since this matter came to light on Friday. And although I think they are nearing a fuller understanding, it's likely that they're going to need some time before providing perhaps an update to this statement to explain the position more completely. So procedurally, we intend to proceed as best we can with the evidence this week. We'll do the best that we can with the disclosure. We'll need to make allowance for the fact that my learned friends for other core participants have not seen this material save in the last 24 hours. And there may be some need for some supplementary Rule 9 statement requests to be made in individual cases of the local authority's own witnesses, and perhaps in individual cases of witnesses who've already given evidence.
Thank you very much indeed, Mr. Moss. Ms. Johnson, I know that this has been a source of considerable embarrassment to both yourself and those who instruct you. I am grateful for the unreserved apology that's been offered on more than one occasion in relation to this unfortunate set of events. And of course, I accept those apologies unreservedly. There is clearly some work yet to be done as to precisely what went wrong, and I would be grateful, please, if the final position could be communicated to counsel to the inquiry as soon as it's available. Can I make one observation of my own, and that is looking to the future for other court proceedings, tribunals or other inquiries, that clearly something happened in relation to the way in which the information was locked, in inverted commas, which meant that although Ms. Ashworth had access to all of it, everyone else, including this inquiry, didn't. And there must, I would have thought, be something profoundly wrong with the system in the way that it's currently configured that can possibly allow that to happen. But I'm sure you're fully aware of that, and it doesn't really need for me to repeat it in any greater detail. Unless there's anything else that you would wish to say about it now, I would propose that we simply get on with the evidence. But having, as it were, been put on the spot, I will of course give you the opportunity to say anything at this stage that you would wish to.
So no, simply to repeat the apology and all the observations made and noted. All noticings.
Thank you very much indeed. Shall we have a break?
A break. Thank you.
15 minutes?
Thank you, sir.
We'll sit just before past.
I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Please have a seat. Yes, Mr. Martin.
Thank you, sir. Just start by giving us your full name, if you would.
Sarah Callan.
Thank you, Ms. Callan. If we could have on screen, please, first LCC 201712. Do we see that this is your first statement to this inquiry? It's dated the 21st of August 2025, and are the contents of that statement true to the best of your knowledge and belief?
They are.
Thank you. Then can we have next on the screen, please, Sarah, LCC 002132. This is a second statement that you made to the inquiry. Sorry, 2134, my mistake. Forgive me. LCC 002134. It's dated the 10th of October, and are the contents of that second statement true to the best of your knowledge and belief as well?
Yes.
Thank you. You can go back to your first statement, please. So that's the one ending 1712. Just have on screen the first page of the statement. Just by way of professional background, do tell us, is this right? You qualified as a social worker back in, was it 1999?
Yes, that's correct.
You've specialised in youth justice, and you've worked for various local authorities and the probation service in your past career.
Yes, that's correct.
You've worked in various management roles in Lancashire Youth Justice Services from 2008 to 2019. We'll just go over the page.
Yes,
Is that right?
that's correct.
And you were a service manager for Blackpool Youth Justice Services from April 29 until April 2021.
I was, yes.
Thank you. You then returned to Lancashire, I think, as the senior manager of the Youth Justice Service from April 2021 to the present day.
Yes, that's correct.
And so, Ms Callan, we should note first and importantly that you weren't in post of the senior manager of the Child and Youth Justice Service at the time that AR had his referral order. You came into post after that.
That's correct, yes.
But you're the current incumbent, and you have made your statement based on, no doubt, a detailed scrutiny of the records and your familiarity with the systems. Would that be fair?
Yes, it would.
Thank you. You help us in your statement, and if we could turn to page 3 with a little bit about the corporate structure and responsibilities. You've set out the statutory framework, first of all, looking at paragraph 5, and you explain there that the principal aim of the youth justice system is to prevent offending by children. Is that right?
That's correct.
And everyone has to have regard to that aim, yes?
Yes.
Local authorities are obliged to have a youth offending team which coordinates the provision of youth justice service, and I think that's where your team comes in.
That's correct, yes.
Thank you. Also in your statement, if we look at paragraph 10, please, on page 4, you've set out a helpful summary of referral orders. You've given quite a lot of detail there. Can you just give an initial overview of what a referral order is and what its aims are?
Okay, so when a child appears before the court on the first occasion, for the first conviction, the outcomes are either a referral order or a detention and training order, so a period in custody. At that point, it's the court decision. If they are looking at a period of custody, they ask for a pre-sentence report. But if they're happy that the child meets the criteria for a referral order, then that is given by the youth court at that point. The child then comes into the youth justice service. We do an assessment and they become open to us for a period of time whilst we undertake intervention with that child.
And the duration of them, I think, a minimum of 3 and a maximum of 12 months, is that right?
That is correct, yes.
Overseen by a panel. Who sits on the panel?
So the panel, we have a range of community volunteers on the panel. So we advertise locally for panel volunteers and they apply. They're members of the local community. We train those panel volunteers. They sit on the panel and they are presented with a referral order report to then set the contract of work that child needs to undertake during the duration of the order.
Thank you. So this is different to a judicial role, but they would have a report in front of them and they would, on the basis of that report, agree a contract of work that should be done during the referral order by the child in question.
That is correct, yes.
I don't think that panel would have any sentencing powers itself, but is it right that if the child does not abide by the terms of the contract, they can be referred back to the court?
Yeah, so what would happen was if the child failed to comply, the practitioner working with the child would refer the child back to the panel. The panel would then review the progress that the child had made, and if deemed necessary, the panel would then refer the matter back to the Youth Justice Service to breach the child, in essence, return them to court.
Thank you. And in those circumstances, that could lead potentially to the term of the referral order being extended, although not, I think, beyond the maximum of 12 months. Is that right?
That is correct.
But potentially more seriously for the child, they could be resentenced for the original offence. Yes?
That is correct.
If we could have on screen, please, paragraph 19. Sarah, it's page 6. You deal with it in paragraph 19, so I put it on screen for you, but just give us a flavour of some of the kinds of things that can be a feature of a referral order, so what the child is required to do.
So it's very much based on the needs of that individual child. I think over the time we've come to develop our use of referral orders within the criminal justice or the youth justice service to make sure that they are very child first and specific to the needs of that child. So as mentioned in my statement, there's unpaid work, so some form of reparation to the community and or to the victim. We ask them to participate and undertake specific interventions, so it may be around offending behaviour work, it could be specific to anger management, it could be specific around education. There's a variety of different programmes that we can ask the child to complete with our social workers within, or youth justice workers within our service.
Now, you say in your answer there that it could be very specific to the needs of the child. You'll understand that this is an inquiry that is focusing on the risks that AR posed to others. When you speak in your managerial responsibility for the Child and Youth Justice Service about the specific needs of the child being key to a referral order, does that include the need to take action in relation to that child's risk to other people?
Do you mean in terms of assessment?
No, in terms of dealing during the referral order, not with what the needs of the child are, but in terms of the needs of society to try to address and mitigate the risk of further offences of violence against others.
Part of the interventions that we would do as a service address the needs of that child, which should be taken from the assessment, which forms the basis of the needs, safety and well-being of the child, but also risk of serious harm to others. So those assessments which are done, the assessment's done of the child at the start of the order and at various points throughout that order should inform the assessment and the interventions.
Right. Even in the language that you've used in that answer, you started, it's not a criticism of you, but I wish to explore it. You said part of the interventions that we would do as a service address the needs of that child, which should be taken from the assessment. And then you go on to say that include the risk to others. It may suggest a very child-centric approach, which may not be a bad thing, but there are rights of others involved, as well as the child, where there is violence against others that has been perpetrated. Would you agree?
Yes.
How is that balance struck?
Try and balance that through developing that intervention plan with the child. So whilst we are a trauma-informed child-first restorative service, we balance that with the needs of the child alongside protection of the public and risk management. So whilst we may do an intervention around anger management, for example, so very much focusing on the way the child deals with their emotionals and behaviour, but how then that would then impact their behaviour, say, for example, in the community. Or it could be in terms of sort of attendance at school, encouraging the child to attend school, because if we get a child back into school or a child's working closely with school, it then reduces the risk of them being out in the community, reduces risks of reoffending.
One can understand that the needs of the child and the need to address that child's risk of perpetrating violence on others may align. But starting in a way at the end, looking completely at the intervention of your service with AR, do you think that there was sufficient attention to the risks that he posed to others, to members of the public, to other children?
It's very difficult to say because I wasn't obviously there at the time. However, having reviewed the assessments and the record for AR, the practitioners in post at the time would appear to have followed the Youth Justice Board guidance in terms of risk management and risk assessment. There was clear guidance in place for the Asset Plus assessment in 2014, which when reviewing that against the assessment, it would appear that worker and the managers have worked in line with those pieces of guidance. It is a professional judgment from that worker at that point and that manager, and therefore it is quite difficult for me to comment in terms of that professional judgment that they've made at that point.
We'll come back to that. I think national oversight is provided by the Youth Justice Board, is that right?
That is correct.
Deal with that certainly on note in paragraphs 24 to 27.
Thank you.
We're going to hear from them in due course. But in short, although they provide guidance and will pick up themes, I don't think that they would get involved in individual cases. Is that right?
That is correct.
Thank you. You've mentioned Asset Plus already. We know that that's a key part of the guidance. Just explain briefly what Asset Plus is.
So Asset Plus is the intervention, the assessment tool Youth Justice Services use to assess all children coming in to the service on statutory or out-of-court disposals. It's a lengthy document which provides a holistic oversight and view of that child. We would expect a social worker in Lancashire to complete that assessment on the child, and that assessment is used to inform the intervention plan for that child moving forward.
Holistic oversight. What does that really mean?
So to complete the assessment, it would be my expectation that the worker would speak to the child, speak to the family, parent, carers to inform that assessment, and also speak to partner agencies. So if we have partner agencies involved with a child, it would be my expectation that that practitioner speaks to those agencies to do research, to find out what their views are of the child, working relationships, gather all that information in one place to be able to inform that assessment to then inform the intervention plan.
And as you rightly identify in paragraph 65 of your statement on page 19, good quality assessment is the foundation of effective youth justice practice. Yes?
Yes.
And good quality assessment, presumably, in turn, is dependent upon the Child and Youth Justice Service sucking in as much information as it reasonably can to inform the assessment.
Yes, that's correct. And then analysing it as well, not just putting it down on paper.
Yeah.
It needs some of that analysis behind it as well.
And again, recognising that you weren't in place at the time and are coming to this corporately, has the Child and Youth Justice Service looked very carefully at the totality of information that could have been available to see whether the assessment of risk was fully and properly informed in AR's case?
I think there is clearly information missing from that risk assessment, in my professional opinion.
What information?
In terms of some of the information we've read since, some of the information that's been shared with me as part of this inquiry, in terms of some of the information that happened prior, I think it was prior
Yes.
to our involvement.
What information is that?
In relation to the carrying of there was information around carrying of a knife in school. Is that correct? I'd need to refer to my notes, sorry.
Well, you'll forgive me, but I'm asking you because I started my question in a way by asking about overall the effectiveness of that, and you said they followed practice and policy, and I said that I'd come back to it. And I've taken you to the fact that the assessment of risk can surely be only good as the obtaining of information. And I asked if you thought that information had been adequately obtained by the Child and Youth Justice Service, recognising it's not your personal responsibility, but whether your corporate assessment of that has looked at the detail of it.
I think there is evidence that we have collected some information in terms of that risk management. I think, from my professional opinion, obviously I wasn't there at that time, whether all information is used and analysed appropriately within that risk assessment there may be different views and opinions on that. I think it is clear from that risk assessment that they did follow that procedure in terms of, with the Youth Justice Board, they explained to us to look 6 months in advance and to consider some of the information at the time. So we did consult with school, consulted with CFW, spoke to parents and obviously spoke to the child, and the risk assessment is done for that period of 6 months. The case manager, or the social worker, who was actually doing the risk assessment at that point, would have looked at previous offending behaviour, sort of previous offences, whether they've been known to services previously, and all that information should then inform that risk assessment.
All right, well, we'll come on to the detail. So for your note, the Asset Plus guidance is LCC 001732.
Thank you very much.
I think within that, we're going to look at some of the outputs from that. But I think, can you help us just with some key concepts? So the Asset Plus is looking, amongst other things, is this right, at the assessment of the risk of serious harm.
That's correct.
And serious harm, I think, for these purposes, so for your note, LCC 001738 at page 5, is defined as death or injury, either physical or psychological, which is life-threatening and or traumatic, and from which recovery is expected to be difficult, incomplete, or impossible. Yes?
Yes.
So that has a specific meaning, the risk of serious harm. And then there are bandings, aren't they, that run from low to very high. Yes?
Yes.
And low, I think, has a technical definition of no evidence at present to indicate likelihood of serious harmful behaviour in future. Yes? Medium is some risk identified, but young person is unlikely to cause serious harm unless circumstances change.
Yeah.
Yeah. High is risk of serious harm identified. The potential event could happen any time, and the impact would be serious. Yes?
Correct.
And then very high, imminent risk of serious harm identified. The young person will commit the behaviour in question as soon as the opportunity arises. Are those, again, the technical definitions of the risk bandings? Thank you. So I'm looking at this for reasons you'll understand about the risk to others, but I think there are similar provisions in terms of risk to the child's own safety and well-being, but I'm not going to go to those, but they are dealt with within the Asset Plus guidance, yes?
Yes.
And then there's also a youth offender group reconviction scale, and perhaps we don't particularly need every detail in relation to that, but that is effectively getting a sort of actuarial calculation based on the information that's been obtained on the likelihood of reoffending within 2 years. Yes?
Yes, that's correct.
There'll be an element of professional judgment in that, but there's quite a lot of inputs that lead to a score.
Yeah, they're based more on static factors.
Thank you. And then you've touched on this already, but if we just look at it in your statement, paragraph 72, page 22, please. Ms. Callan, these assessments are meant to be looking to the near future. Is that right?
Yes, 6 months.
And in reality, as you've mentioned in passing, that's treated as being for the next 6 months. Mm-hmm. Yes?
That's correct.
Thank you. So there's associated guidance that's dealt with, which I don't think it's necessary for me to go to, but may I just put on record the references. So the referral order, report and contract guidance, LCC 001741, adjustments made to the referral order process because of the pandemic, LCC 001745 and LCC 001749. And then, Ms. Callan, you helpfully in your second witness statement, which we don't otherwise need to turn up, dealt with the effective case management oversight framework. Just tell us very briefly what that is.
So we developed, or Lancashire developed, I wasn't in post at the time, an effective case management oversight framework which puts in place expectations from practitioners and also from managers in terms of oversight of the work of the practitioners within the service.
Thank you. So you have the April 2019 version at LCC 002002, You have the October 21 version at LCC 002003, those are all references that are set out in the statement, which I'm not going to take you to, but they're helpful to have those available. Thank you. Thank you. Can we turn to just understanding a little bit, having looked at the framework and the tests and the guidance, can we just look at how it worked in Lancashire, please, in terms of where the Child and Youth Justice Service fits in? If we look at paragraph 28 of your statement, it's right, isn't it, that the Child and Youth Justice Service was and the youth offending team sat within the wider children's social care structure.
Yes.
Yep. And so if we look at LCC 001762, reminding ourselves that this is part of the overall children's social care team in the local authority. We see there the head of service grade at the top. So where do they sit? What are they controlling and overseeing?
At that time, it is in my statement, but I think at that time Barbara Bath, as the head of service, was head of fostering and adoption, the youth justice service and residential services in Lancashire.
Right, so a panoply of responsibilities, and then within that, you've got the Youth Justice Senior Manager, yes?
Yes.
Caroline Entwistle, yes?
Yes.
Was she your predecessor?
No, there was a restructure in 2021, which was when I applied for the post and came back to Lancashire.
But we then see a number of team managers, and on the right-hand side, we can see that there are a number of practice manager for operations, and I think that the youth offending team who had practical contact with AR were in the operations team, yes?
That's correct.
Can you help us just briefly, please, with the teams that we see on the left-hand side in terms of those who are described as being in prevention teams? Can you help with that?
In terms of explaining the difference?
Yeah, what sort of work they would have been involved in, just so that we get a feel of it. We're going to concentrate on operations, but I just want to understand what they would have been involved in.
So the prevention and diversion side of the service focused very much on the prevention officer at Lancashire were developing and had started to develop. Also the diversion part of the service. So children coming into the service for out-of-court resolutions, those lower level interventions, they would primarily be picked up by the prevention and diversion part of the service, whereas the operations part of the service dealt with more statutory court orders.
Thank you. So we know that AR went to court, was dealt with through the criminal justice and received a sentence of a referral order, so came to the operations team. If it had been a less serious offence and it had not gone to court for a prosecution, there could have been a diversion, and it would have been the yacht working in the diversion team who might then have worked for him. Would that be right?
Yes, that would be correct.
Okay, so that's diversion, and then prevention, is that more community work, projects to avoid offending in the first place?
Yes, it is. So it's developed quite a lot over the years. We have a variety of referral pathways in place in terms of social care, children's social care police, CFW, who can refer into our service for sort of specific pieces of work for children who they deem at risk or potentially at risk of coming into the more formal criminal justice route.
And that could be at an individual level if there was felt to be a need to engage in prevention work with an individual?
Yeah, it mainly is on an individual level.
Thank you. On the operations side, would the caseworkers at ground level, what would their qualifications be? Would they be social workers, probation officers by background, combination of both?
We have social workers mainly, and we do have an allocation nationally of 2 seconded probation officers. but the rest are social workers. We do have some unqualified or not social work qualified support workers also in post to work alongside the social workers.
Thank you. Now, if we just bear in mind the prevention and diversion parts of that diagram, that can come down from the screen, but I don't want to forget about that altogether. So that can come down from the screen. If we go back to your statement, please, and look at page 12. LCC 001712, page 12, top of the page. Paragraphs 38 and 39, you say that a role can start prior to conviction and sentencing, but paragraph 39 in AL's case, Child and Youth Justice Services had no role prior to his conviction. Is that right?
That is correct.
We know that in general terms, the involvement of the youth offending team in AR's case followed the referral order, yes?
Yes.
But prior to that, there had been the October 2019 involvement with AR and knives, where he'd phoned Childline, he'd admitted that on 10 occasions he'd brought a knife to school and made disclosures, some of which included an intention to use that knife against somebody who he perceived to have been bullying him. Do you know why the diversional prevention team from the Child and Youth Justice Services weren't engaged at that stage?
It's difficult for me to say because I wasn't in post at that point. However, as I just mentioned, the referral routes are through from the police, children's social care, CFW. So for us to start working with AR at that case would have had to have a referral through for us to become aware of him.
And so far as you're aware, was there no such referral?
Not as far as I'm aware.
Do you think that may have been something of a missed opportunity for youth offending team workers to get involved slightly earlier than they did?
Potentially, it could have been, if a referral had come through, we could have done a screening, spoken to partner agencies who were involved, and then made a decision in terms of what the intervention, if there was a role for youth justice services at that point.
Would that not be a reasonably classic sort of case where there would have been a role for diversion or prevention?
It's very difficult to say. We get referrals from our partner agencies for a variety of different children and their needs. Potentially, it could have been, yes.
Thank you. We know that there were two strategy meetings involving AR, one on the 17th of December of 2019, one of the 6th of January. I don't think that the Child and Youth Justice Service was invited to either of those, were they?
No, they weren't.
Again, by that stage, there has been the commission of the hockey stick incident with the knife. So you've then got two separate involvements with knives, one with the actual commission of a serious offence, and appreciating that the youth justice team got involved at the sentencing stage. Again, there might have been a role earlier at those strategy meetings to get involved early. Would you agree?
Yes.
Do you know why that wasn't done?
No. Sorry.
So in fact, the first involvement of the service, I think paragraph 49 of your statement on page 15, was when the Youth Court made the referral order, which was imposed, I think, on the 19th of February 2020. Is that correct?
That's correct.
Thank you. You explain paragraph 73 of your statement at page 22 that initially the service was provided with a set of documents from the CPS. So your note for these is LCC 4021. Is that correct?
That's correct.
I'm not going to go through those documents in full, but would you agree, I know that you will have looked at them, that they were quite limited, providing just the initial details of the prosecution case, yes?
Yes, I'd agree.
There was one witness statement from the arresting officer. From your analysis of the file, were any steps taken at that stage to obtain the remaining material collated by the Merseyside Police's investigation of the hockey stick incident?
I couldn't see any evidence on the AR's case record that had happened.
Would that not have been good practice to obtain that?
Possibly, yes.
Well, is it possibly, or is it just good practice to do so?
It's good practice to make sure that we would have a full CPS pack.
So we'll leave out the possibly. Should that have been done?
Yes.
Do you know why it wasn't done?
I don't. Sorry, I wasn't in service at the time.
Because that would have opened up the previous concerning behaviour in October 2019 that would have been available from that material, yes?
I can't say whether it would or not because I don't know whether that would have actually formed part of the CPS bundle of documents that we would have been provided.
I think we don't need to go to it to establish this, but I think that evidence would have been available from the Merseyside Police investigation, that there'd been earlier instances of bringing knives to school, and that certainly would have been relevant to the assessment of risk, not just that it had happened, but that you'd done it on 10 occasions. Would you agree?
If it was available, I perhaps would raise the question why the police didn't provide us with it at the time when they provided the other documents.
As you explain in paragraph 77, the first direct contact between AR and his family and your service was on the 26th of February with an assessment meeting at the family home by Anna Kroll. And Ms. Kroll, I think, was the allocated caseworker for the early months, yes?
Yes.
Come on to the handover to another caseworker. If we look at LCC 30488, page 31, second entry. What do you make of that as a record of the assessment meeting?
Poor quality. I would expect further information within that contact.
It does nothing but record, really, the fact that it had happened and one of the other people attending.
That's correct.
What's the purpose of an initial assessment meeting?
So the initial assessment meeting is to start to gather the information for the initial Asset Plus assessment. By the looks of the limited information we have in this contact that it took place in the family home, one could presume that the child would have been there, the parents' carers potentially would have been there, and that meeting would be to start to collate together the information to inform that initial assessment.
And it should be recorded?
It should be.
And it's not?
Correct.
There was then a multi-agency strategy meeting on the 4th of March. So far as the notes of this are concerned, if we just go to the top of the same page, please, Sarah. One sees that there. The first two lines are taken up with just recording who is there. And then the only notes are that it's closed to the Criminal Justice Liaison and Diversion Service, Merseycare. School's sending work home, but it isn't being returned, either too easy or too hard. School didn't know the risks, therefore, educated at home. What do you make of that as a record?
It doesn't tell us very much in terms of that multi-agency meeting. I would expect a fuller contact when a professionals meeting, multi-agency meeting has taken place.
Again, if the risk assessments are only going to be as good as the information that's obtained, this was not a very good start.
No.
If we look at LCC 001346, please, this is the record that Acorns made. So LCC 001346, page 58. Thank you. If that can just be highlighted, please, if we just cut out the bottom third so that the text is a bit more legible. The contrast in level of detail is quite striking, would you agree?
I would.
I won't go through this line by line, but it does record Ms. Jameson opening the meeting by setting out the findings of their CNF assessment, and that Prevent were not going to take further action, and CAMS hadn't identified any further mental health issues. So your service, again, whenever I say your service, one appreciates you weren't in place at the time, but your service were put on notice by that there had been a Prevent referral.
Yes.
And then there's a reference to an email that had been received by Alfonso, AR's father, and that's been looked at a number of times, but it included reference to the fact that AR is a good boy, modest and respectful. He's not a risk to himself or to others. From this record, it's fair to say, isn't it, that Acorns disputed the views of AR's father and were concerned about the risk posed by AR and that it was being minimised by his parents. Yes?
Yes.
We see in this note, it's about in the middle of the page, it's probably fine as it is, Sarah, but I'm just for Ms. Callan helping her to navigate. We see Anna Kroll's input is noted there, and we see that she said that AR was presenting as medium to high risk. Yes?
Yes.
Further established that although his needs were being met by parents at home and there were no safeguarding concerns within the family, it was unclear the level of risk in other environments. So there was an openness there to some unknowns at that stage about the extent of the risk in other environments. Would you agree?
Yes.
And there you see, immediately thereafter, education staff maintained that AR could not attend the school premises or an alternative venue with staff until all professionals had completed a multi-agency risk assessment in line with working together to safeguard children.
Yes.
So your service was on notice about how concerned Acorns were about the risk.
Yes.
Because they were refusing to educate him at school or anywhere else until there'd been a proper assessment of risk. Yes?
Yes.
There's then further information, including school's indication of concern about the extent to which he was fixated on individual staff and pupils, and father not accepting what school staff were saying, and his refusal to engage with Acorns or indeed with early help regarding those concerns and the hockey stick attack. At this stage, would you agree that there was an obvious need for the caseworker, Ms. Kroll, to obtain as much information as possible about the earlier incidents, so the hockey stick incident and the earlier incidents in October.
Yes.
And in particular, about AR's intentions with the knife in relation to both of those events.
It would have been part of her information gathering, I would have expected, in terms of to inform that assessment, to gather a full picture.
We don't see anything, as we've looked at, on the Child and Youth Justice Service's account of this meeting to show that was done. And from this more detailed note from Acorns, there doesn't seem to have been recorded any probing by Ms. Kroll as to the detail of the circumstances of the earlier events.
There's no evidence that she did that on the record.
And if we look, please, at a different document, which is LCC 30452. This is the initial panel report. And if we go to page 2, please, and then on to page 3, we see reference to background circumstances. We see summarised that AR has previously attended the Range School in Formby but was expelled in October 2019 after it was discovered that AR was taking a knife into school due to bullying. AR was then educated at the Acorn School until this incident, and after that he'd been educated from home, described as academically able and so on. There's reference to the school describing his behaviour as disruptive, saying he didn't like Acorn School. At the moment, the school won't allow him back until a risk assessment has taken place. And then seeing forensic cams in the next paragraph, now on a waiting list for explanation of diagnosis of ASD. Doesn't have a history of children's service involvement. AR was referred to Children's Services in October 2019. However, the matter was referred to Child and Families Wellbeing Service, but was not reported that there was, reported there was little engagement. Reference to what happened after the offence was referred to. Family have closed to Children's Services and will be receiving support through Child and Families Wellbeing. Doesn't have positive uses of his time. AR enjoys watching TV and gaming on his computer, but he appears very socially isolated, not having many friends. Now he's not in school, he'll have limited opportunities for that. Parents want to get him involved in clubs, but AR is reluctant to do this as he reports that he's not been allowed to do this before. Prior to this incident, AR has not had any involvement in the criminal justice system. Then if we go over the page, offence information, interviewed about the offence, cooperated. AR describes that he'd been bullied for a number of weeks at his previous school. At this time, AR was attending Acorn School in Ormskirk. He took a taxi to the former school, the Range, got to the school, entered the premises, teacher sees him, and so on. AR describes that the teacher was chasing him, but he did not stop, took a hockey stick from underneath his jacket and struck another person. AR said that he'd gone to school to confront a young person who'd been bullying him. He states he told adults about the bullying, but they hadn't done anything about him. AR looked for the other young person, but couldn't find him as he wasn't in school that day. At this point, AR was described as taking a hockey stick out of his cage and attacking a group of Year 9 pupils, struck one of those, causing reddening to his hand and arms, restrained and taken to the head teacher's office. Asked if he'd previously had any trouble with young persons who he attacked, which he denied. When asked about his actions, AR stated they were wrong, as the young person hadn't done anything to him. AR told the police that due to the teachers following him, he decided to attack the other person as he knew he'd get into trouble, so may as well do something to get into trouble for. Now, that was concerning, would you agree, that last aspect?
Yes.
When AR was stopped and taken into the school office, it was discovered that he had a knife in his bag. AR informed the police that he'd taken the knife with him. AR told me that he wasn't sure why he had the knife, as he hadn't planned to use it. he did admit to wanting to assault the other young person who was not in school. AR does appear to recognise that his actions were wrong and so on. Now, in fact, at the time of the hockey stick attack, AR gave indications that he would have been prepared to use the knife, and on some of his accounts, both in relation to October 2019 and December 2019, he appears to have accepted that his intention was to kill the victim, or to at least cause very serious harm, and that he would have been prepared to use the knife if the hockey stick hadn't done the job. Yes?
That isn't reflected in our contacts. So without going back through the initial assessment, I'm unsure if we were aware of those specific details in terms of, I'm aware that, excuse me, we were aware that he'd carried a knife, but just in terms of the mention of him wanting to kill other people.
To kill the intended subject, the
Yeah.
person who perceived to be a bully. That was fundamental, wasn't it, to the assessment of risk?
Yeah, but I'm not sure if we were aware of that specific detail.
No, it would be very odd if Ms. Kroll was aware of that detail if she hadn't mentioned it in the report to the board. Would you agree?
Yes.
But that is the difficulty, I suggest, Ms. Callan, again, not against you personally, but against the service, in terms of not taking adequate steps right at the start to pull the relevant information in.
Yes, I would agree. And that's the importance of, youth justice teams are a multi-agency team. We do have a variety of partners, and there is that expectation in terms of gathering that information to inform that initial assessment.
Yes, but that only goes so far, because there's also the duty to be professionally curious and to pull the information in. And in circumstances where she was an attendee at a meeting, where the schools were present, one would expect that to be probed. But what seems to have happened is the opposite, that Ms. Kroll has taken at face value and reported to the board, to the panel, I should say, an account that he hadn't planned to use it.
I think the quality of the information within the report, whilst there's some elements of it which are correct and explain the situations, there are clearly elements missing from the report.
Well, they're fundamental issues missing, aren't they?
There are.
Which would have been very significant in colouring and grading the assessment of risk, because it's one thing for a boy in a misguided sense perhaps of bravado or even self-defence to carry a knife, but it's quite another to do so on 10 occasions and then a few months later to carry a knife again and to make an admission, which he did, that he carried it in part with the intention to use it.
I think the information that we're aware of hasn't been reflected adequately or appropriately within the assessment.
And you'll understand now why early in my questioning I took you to what your investigations and your corporate overview had shown, because it may be that looking at on the face of the CYJS records, that it's reasonable comment to say, as you did 10 or 15 minutes ago, well, they seem to have followed process and policy, but actually they were missing key early information. Would you agree?
Yeah, and I think when we've had the opportunity to look through the record and to dig deeper, there's clear parts of information which haven't made it through, haven't been researched, haven't been gained from the work at the time, and then haven't then gone through to the assessment, to the report, and been shared in terms of the intervention plan.
Important aspects of this risk information was available to the local authority through the early help team and the social care teams who'd been involved and were recorded on their records?
I would have expected, or it would be my expectation now, that the social worker or caseworker would go and speak to people who are, other professionals where the child's open to, and gather that information. So there is a reliance on other partners, professionals working with the child, to share that information with ourselves to enable us to become aware of it, to put it in our assessments.
Thank you. So moving on, the referral order contract that resulted in the initial assessments, if we look at paragraph 82 on page 24 of your statement, the initial panel meeting, I think, was on the 24th of March 2020?
Yes.
Conducted by telephone?
Yes, that would appear.
Would that normally have been in person were it not for COVID?
Yes, that is correct.
You say that the terms of contract would have been explained to AR and to Alphonse. And then in paragraph 161 at page 58, I think because of a later file migration system in 2023, the referral order contract itself is no longer available to you and therefore not available to the inquiry.
That is correct. We moved case management systems, as it says, in 2023. It's not clear whether, even though we did the user acceptance testing and the migration was overall complete, whether that became unable to be pulled off the system as a result of that migration, or if the case management supplier said that it could have been corrupt before the migration of the data.
In fairness, that wouldn't have had an impact at the time because the contract would have been visible. But would you agree that's a significant systems information or information systems failure later on, because it makes it harder for the inquiry to understand how the referral order was managed and why?
It does. However, in some of the detailed contacts, there is information that we've managed to pull when we look at all the contacts in terms of what that initial referral order panel member had said at the initial telephone referral order panel in terms of what that contract should include.
Yeah, so we can have a fair idea by piecing it together.
Yes.
So work on anger management, risk of knives, we can see some of that work being done, I think, later by Mr. Fitzpatrick, and from that you can work back to some extent.
There's a contact on Corporal, on the record, on the child's record, which actually details the feedback from the referral order volunteer, which says, sort of details what work she would like him to do.
So, fine, thank you. Thank you. I think in relation to the feedback, focus didn't it on his isolation, seeking for him to join in clubs in the local community, exploring impact of bullying and his coping mechanisms, and to continue engaging in education. Do you want to have a look at it? It's page 26. LCC 00488, page 26. Sorry, 3 zeros, LCC 3 zeros. Page 26. I think it's the bottom entry. Is that what you were referring to?
Yes.
You've said in your own statement that the objectives were very generic and lacked specific focus. Do you think that's right?
Yeah, I do. Specifically, there is some focus in terms of the referral order volunteer asks for the child, for AR, to look for things in the local community. But some more of the generic recommend or suggestions within this contact would suggest, reparation, a storyboard. There isn't, sort of around bullying. There's not very much. Knife crime or assault, for example. They work around consequences of his actions. It is more generic than potentially we would look for now. We would expect them to be more specific.
The expectations, I don't think we need to bring it up, but for your note, LCC 001752, page 45. The referral order guidance of paragraph 8.33 envisages that the panel should be looking to draw up a package of interventions, including positive activities tailored to the individual case. This is much more generic and nebulous than that, isn't it?
It is, yeah. We were at the start of the pandemic, again, at this stage when this discussion was taking place. Nobody knew what the future was going to look. No matter whether, a couple of weeks or a couple of months forward. And I think it was a challenge at that point for the referral order panel volunteers to know how specific they can be in terms of making some of those requirements as part of that contract.
And one must bear in mind COVID, but according to the guidance for a 10-month order, there should have been a minimum of 30 hours of reparative work within the contract, and that doesn't seem to have been allowed for at all, does it?
No, there's mention within that contact that we were just looking at around choosing some sort of storyboard for game relating to knife crime or assault, for example, as part of sort of a piece of reparation work. And we would, we have got examples where children within service have done pieces of reparation work, tools and resources that we can then use with other children as part of their intervention programme.
Thank you. Could we have next LCC 30452 on the screen, please? We go back to the final page of this. Page 4. Sorry, it's my fault. Page 4, the final page we were looking at before. Page 4, please. This did avert to the previous expulsion from the range. But all of this was putting matters down to bullying, would you agree, as his motivation?
That's, from what I've read on the case record, that's what, yes, I understand.
Again, have you seen anything on the Child and Youth Justice Service records that reflects the fact that both the range and Acorns were clear in their thinking that objectively speaking, there hadn't been bullying?
I've not seen it clear on the youth justice system through the assessments that I've read and the information such as this referral order report. It does all make reference to bullying.
If we go over to page 5, please. It indicates there that AR's parents appear to feel disappointed about what happened. They feel that bullying has pushed AR towards his actions, and that his father had written in saying that he thought the Acorn School had contributed to the offence. Yes?
That's what I can read.
And Section 5, AR has supportive parents who provide pro-social values. If, in fact, what was happening was that AR's father was to some extent blaming the school for having contributed to the offence and suggesting that AR had been pushed to carrying knives by bullying, and that AR's father was writing in to professionals to make these points. How does that tie in with a protective factor being identified that AR had supportive parents who provide pro-social values? The father was minimising and deflecting blame, wasn't he?
It's difficult in terms of that social worker's professional judgment and opinion at that time, in terms of she's obviously made that statement within this report. I don't know how she came to that conclusion for this report. I presume one would think from the completed assessment from the people and professionals who she's been speaking to. However, given what you've just referenced, one view could be that that was his parents possibly not providing pro-social values in terms of the items, the areas that you've just mentioned.
We see at the bottom, overview of likelihood of reoffending is mentioned. If we just go over the page, the assessment of medium at that time, and we reacted to a situation that he could not manage appropriately. On the occasions we know about AR was carried weapons, this has been in response to a certain perceived threat. Although it doesn't justify his actions, it does provide some insight into when AR may engage in offending behaviour. In light of the additional information about the number of times that he'd previously carried knives and his intention to use the knife, does the risk of reoffending being at medium now seem right to you?
Sorry, which part of the document were you just referring to there?
I was reading from the top. When considering risk of reoffending, I've assessed AR as medium at this time, and then she reports that he reacted to a situation that he could not manage. When he's carried weapons, it's been in response to certain perceived threats. It doesn't justify it, but it gives insight into it and gives insight into triggers. With the additional information that schools didn't believe he was being bullied at all, and the seriousness of the weapon carrying previously, does that now call into question the risk of reoffending being assessed at medium?
Again, it's difficult for me to comment. Obviously, the social worker has made that judgment based on her professional opinion at the time, the information she has gathered. One could possibly say that he would have been high. I would have expected her to have been using the Youth Justice Board guidance in terms of those risk levels, risk of reoffending levels that we may have discussed earlier. It's very difficult for me to comment based on her professional judgment in making that risk level.
When you look at the second paragraph, when considering risk of serious harm, there's no doubt that AR may have caused serious harm if he'd found his intended victim or if he continued to attack. But the fact that AR was carrying knives is a concern, but I note that he did not use them, and there's no intelligence to suggest he's taken them in the community. Lack of antecedent history and so on. Quite apart from the issue of the stated intention to use the knife if necessary, if he couldn't cause harm with the hockey stick, it was also a carefully premeditated attack, wasn't it? I mean, he'd booked a taxi the night before to go to a school that wasn't his own, to go back to his own school. This wasn't spontaneous at all. It's planned, deliberate, calculated.
I'm not sure if that information in terms of him booking the taxi the night before I was aware of. I'm not sure if that was
but that's, in a sense, the point.
In terms of that premeditation,
yeah.
Sorry.
With that information, this was an underestimate of the risk of reoffending. Would you agree?
Again, potentially, this is the social worker's professional judgment at that time.
Ms. Callan, I understand that it is their professional judgment at the time, but you are a senior manager who's here in a corporate capacity, so help us. With that additional information, had that been known and established, the risk of reoffending should not have been assessed at medium, should it?
Potentially not. Potentially it should have been assessed higher.
Why potentially?
Because at this stage we don't know. We look at offending behaviour, that information in terms of when we're doing our risk of reoffending, we're looking at convictions, but out of court disposals, that sort of information that's coming through from the police. We didn't have it. This was the first offence. Conviction had come through. In terms of that information, the other information had shared, it's whether it would be useful to look at the risk judgments again, to look at where it sits in terms of that imminence and the risk of serious harm, where that sits again. It's useful to refer back to that, I think.
But although you say this is the first offence, there's admitted from his own admission, there's two separate occasions. Criminal justice has only acted in relation to the December one, but there were the 10 carrying of knives leading up to the call to Childline in October, and then the premeditated attack in December.
It's whether
I'm just wondering why potentially comes into it when you look at that picture and the seriousness and the pre-planning of the attack.
Yeah, and it clearly is serious. It's trying to balance all the factors, all the information that we would receive, for example, from school that we've discussed, from the police. And yes, it may have resulted in a high risk of reoffending.
Medium risk means there's some risk identified, but the young person is unlikely to cause serious harm unless the circumstances change. So, with all of that information, that description wouldn't fit, would it?
No.
And if the risk had been high, what difference would that have made in terms of the involvement of the service?
We would have had more contacts with him. So instead of being seen, we had the scaled approach level at that point. So we'd have been seen at an intensive level, which is the higher level in terms of number of appointments per week. And then that would then be reviewed every 3 months and potentially reduced depending on those levels of risk moving forward.
Would concern have been raised by your service, do you think, if it was high risk of reoffending? We'll come on to harm, but I'm going to suggest high risk of harm as well. Would concern have been raised by your team about the proposal to step AR down from children's social care to CFWS?
Yeah, we would have. I would have hoped that we would have then been part of some of those discussions and those meetings. Although I think they'd have probably taken place before we started.
And then in the Asset Plus, that wasn't, of course, the Asset Plus assessment. That's the preliminary report. But if we go to the Asset Plus assessment, LCC 30447. Just to identify the document first. All right, so I'm not going to go through the detail of this, but that's the Asset Plus record itself, yes?
Is this the start Asset Plus?
Yeah.
Sorry, yes.
Thank you. So the reason why I'm not going to go through that is you very helpfully for us summarised it in your statement, the key aspects to it. You may have a full copy of your statement available, but if we just look at your statement at page 29, please, it's paragraph 93 onwards. You'd agree that the assessment, the initial assessment, was a detailed one, yes?
Yes.
Looking overall, based on, I'm taking your statement as a whole here, as well as the Asset Plus assessment, The factors that were being relied on to justify medium risk were lack of opportunity,
So
I'm trying to take it from the summary, but
yes.
if you go to paragraph 116. It's probably the most helpful paragraph to have out in front of you. Next page. Lack of opportunity and some equivocation from AR about whether he intended to cause serious harm. That was the rationale, would you agree?
Yeah.
But especially with the further information that it appears Ms. Kroll hadn't obtained, there are a whole host of factors here pointing to areas of concern, and I'm going to list them by reference to the Asset Plus guidance itself without turning that up. But there was weapons, yes?
Yes.
Deliberate targeting of victim,
Yes.
yeah. Concerns over AR's ability to recognise the impact and the seriousness of his offending.
Yes.
There was at least a degree of equivocation on the part of his parents about the severity of the offence.
Yes.
He was using, would you agree, unduly sophisticated methods for his age. So he adapted the hockey stick, he booked a taxi the night before. Those are all very concerning for a boy of AR's age at that time. On one view, this could have been practice for more serious offending. The carriage of the knives could be interpreted in that way.
Yeah.
Under patterns and attitudes in the guidance, he thinks that certain motives justify him. So his perception of bullying, he thinks, justifies his actions.
Yes.
Thinks that the victim deserved it. Not the actual victim who he chose to attack, but the original victim he was going for. Other behaviours of particular concern, well, October 2019, he's carried a knife 10 times previously into school, yes?
Mm-hmm. Yes.
So although there's no forensic history in that sense in terms of previous offending behaviour known to the courts, he was known to have carried knives previously.
Not sure if the court would have been aware of that.
Yeah, there was no court action in relation to that.
Sorry, no.
But in terms of the assessment of risk, other behaviours of particular concern, page 104 of the guidance, he has a history of threatening aggressive behaviour because he's carried knives to school previously on 10 occasions.
Yes. Whether he's used them to threaten, I wasn't aware of that.
Yeah. Young person has said, indicate or threatened that he might cause serious harm to others. That was met in this case.
Yes.
Indications of planning or preparing to commit the offences, definitely met.
Mm-hmm.
Behaviour driven by obsessions, fantasies or other problematic interests. Well, by this stage there was information from Acorns that suggests a pattern of concerning behaviour, internet activity, school shootings, terrorist attacks being looked at, an interest in weapons. Those were met too.
Yes.
And when you then add on the information that doesn't appear in Ms. Kroll's records, but was knowable in relation to a serious intent to use the knife, the assessment of risk at medium was wrong.
Yes, I would agree.
Ms. Callan, you've provided a lot of information in your statement, and it includes sections on reflections and lessons learned, and they're helpful. But nowhere in your statement do we find that acceptance that you've just given in answer to me.
Yes, no.
Why not?
I think having looked at it in line with sort of the further information. You know, when we reviewed the assessment, we were reviewing it very much in terms of against the guidance. I think looking at perhaps the bigger picture, having some more information available to review it would make me think that that risk assessment should have been high.
One understands that, but as recently as the 10th of October this month, you provided a second statement. Again, it's helpful, and I'm not criticising it as a statement, but there was an opportunity to say on behalf of the County Council and on behalf of the Child and Youth Justice Service that I need to add to my first statement, because with the information that we now have, I would accept that the service got the assessment of risk wrong.
Yeah, I apologise.
Thank you. If we turn then to matters during the referral order, there were dealings in April and May between Ms Kroll and AR. They were by telephone, and I think you would agree that on a fair assessment that COVID there made matters difficult, yes?
Yes.
Thank you. Would you agree that in terms of some of the meetings that were attended, so the team around the family meetings, for example, that were attended though, that the CYJS, again, didn't take good minutes of those? They were depending on the notes taken by others?
Yes, they were. We would usually expect a contact to be put on the system to give an overview of the meeting and then with the meeting notes to follow and to be attached.
In general terms, I think what's recorded at this stage, with COVID impacts taken into account, is that Ms Kroll was having weekly contact with the family and challenging conversations around AR's behaviours. It was difficult to complete work over the phone.
That's according,
right?
Yeah. I'm not sure what those challenging conversations will have, because I think the details of the contacts aren't clear and aren't detailed.
And it's recorded in the 19th of May 2020 interaction that there was an agreement to share a summary of the report completed on risk. That would have been a reference to the Asset Plus assessment that we've been looking at, yes?
Yes.
Thank you. Within that, there's also reference to the involvement in the meeting with Dr. Ramsey, an educational psychologist, who was in attendance at the same meeting on the 19th of May. Do you know what the purpose of that was?
Not off the top of my
head. By Dr. Ramsey, all right.
Sorry, no.
If we could just look at LCC 001018, please. Thank you. And if we could just look at page 2, this is the 19th of May meeting. We just have that. So this is Anna Kroll's reference. We see there no role to prevent deemed as no risk at the bottom. Do you know how that arose in discussions and looking at the chronology, that what was, one accepts it's not a verbatim note, but deemed as no risk for prevent might be thought to not properly capture what had happened with the first referral to prevent?
Can I just clarify, these Anna's notes? I've not...
No, I don't think they are her notes. I think they are notes that are taken of the meeting by the 19th of May, but they're not her notes, but they're recording her contribution at the meeting.
It's difficult to say what that means. If that's somebody else's perhaps interpretation of what she said, she might have said that, but it doesn't give me any information or what that might mean or why she said that in the meeting, if she did say it.
All right. summarising quite a lot of information that can come down from the screen, summarising quite a bit of information from the chronology and taking it as short as I can. Following that meeting, we know that Ms Hodson contacted Ms Kroll as well as Ms Fontaine to express concerns about the level of risk that AR posed and the failure of AR's father to challenge or confront the risk. Are you familiar with that in general terms?
Yes.
Yeah. In terms of what happened for the youth offending team, for the CYJS, you deal in your statement of paragraph 124, page 39, that she responded by sharing a summary of the April 20 Asset Plus assessment that we've been looking at. Is that right?
Yes, that's right.
Thank you. What is your reflection now on the fact that only the summary was shared with the school rather than the entirety of the assessment?
I think the Asset Plus, as you'll have seen, assessment as a whole document is quite a large document. I think what may have been useful would have been to perhaps for all partners to have sat down together to look at the risk assessment, because I know this was to help inform a risk assessment, wasn't it, for school, and whether it would have been useful for all agencies to sit down with all the information they have to help the school to have collated and developed that risk assessment. I think what I would expect case managers to do is to pull out information which would be useful for the school. I know Anna's tried to do that, hasn't she, with the risk information and the reoffending and the serious harm, safety and wellbeing information, and pass that, share that with school. I think sometimes it's better rather than via email to have it via a meeting, via a discussion. Gives an opportunity for people to ask questions and to clarify points. I'm not sure that, I know it was during COVID, but sharing this sort of information via email is always that helpful.
One can see on this page that Ms Kroll was saying that although I would agree that there's an increased opportunity to commit offences, I think that's because by this time there's consideration of AR being at school more. I do not assess this would push him into the realms of high risk. However, should new information come to light, our risk assessments are reviewed regularly. If we go over the page, if your risk assessment concludes AR can't be in a classroom or school environment, it may be beneficial to discuss this with AR and Alphonse and so on. And then moves into the summary, which is lifted from the Asset Plus. One difficulty in relation to this is that by only sharing the headlines rather than the document itself, it may have meant that Acorns were not able to feed in to your service what they knew about the earlier events, so that the missing information that I've been challenging you about, in a sense, they wouldn't know that that was missing because there was a refusal to provide the whole of the risk assessment.
I'm not sure if it was a refusal. However, I think as a service, we didn't used to provide the whole of assessments with schools. Sometimes there would be victim information in there, personalised sort of information, but we wouldn't usually share. However, what we would do is encourage practitioners to share relevant information from that risk assessment rather than sending them a document. It's around having that discussion, having that meeting to share, rather than just putting it over an email, which I don't think.
But Acorns had been pressing for a detailed risk assessment to be done. One hadn't been done by FCAMS. And in a sense, this was the most detailed risk assessment that was done. The school disputed that it was medium risk, but it still wasn't shared in its totality.
But again, I think, whilst we're one agency and we've done the risk assessment, it's useful to have those discussions on a multi-agency basis. So FCAMS could have shared their information, the police could have shared their information in terms of risk and concerns, which would have all helped the school to develop a succinct risk assessment.
But one consequence of the failure to disclose the totality of the risk assessment and the information, as I put to you, was that the shortcomings in your service's assessment of the risk didn't come to light.
Possibly, yes.
In circumstances where AR was not going out very much outside school attendance at all, which organisation was carrying the actual risk of matters occurring? Where was the risk likely to be greatest in terms of an adverse event happening?
When he wasn't before he went back to school, do you mean?
At this time.
So this is when he wasn't at school?
This is when he's contemplating going back to school, say lockdown has been eased at this time, and they're trying to get him back into school, but he's not going out otherwise in the community.
So I suppose if he went back to school, the risk would be highest at school. Am I understanding your question correctly? Yes. And at which point, within the assessment, the social worker says if situations change, that risk assessment should be reviewed and updated in terms of if he did go back to school.
In a sense, it may be my fault, but perhaps you're missing the point of the question. The place where the risk was most likely at this time to eventuate was his school.
Yes.
The organisation who'd been asking for the risk assessment, but for whom your service was not wishing to share the totality of the risk assessment, the detail of the risk assessment, only the headline conclusions.
We did share, there's quite a bit of information in there. Whether there's been, again, it's sometimes more useful to have a discussion, and some of those multi-agency meetings would be the ideal place where not just youth justice, but other partners who have information regarding risk and risk management can share that information together. So the school have got a thorough risk assessment using a variety of partners. Prevent would have had information at that stage. FCAMS would have had information at that stage. Everybody needed to share that information with school to enable them to get a succinct risk assessment in place.
And who, apart from yourselves, was actually going to do the risk assessment, not the sharing of information, but the assessment of the risk?
It should have been a multi-agency risk assessment.
Yes, but somebody has to collate it together and do an assessment of what that actually points to.
And that comes down to a question around lead agencies and who perhaps at this stage was the lead agency, which again is a challenging question because Youth Justice had statutory responsibility in terms of the court order. School could have been the lead agency because they were seeing the child or would have had the child in school. CFW had responsibility of the TAF. And it's difficult, isn't it, in terms of establishing who is that lead agency, who's that agency that's going to take things forward and coordinate some of these activities that need doing.
One difference is that your team did have some element of compulsive powers at this time, in the sense that if there had not been cooperation, you could have reported that to the panel and gone back to court.
Yes, that's correct.
And should we take it from your answer that you're accepting that there was a lack of clarity about who the lead agency was?
There was, yeah. I don't think, I'm not seeing anything within the records. There doesn't seem to be one agency who was taking the lead in terms of sort of overall coordination of, for example, a risk assessment.
Thank you. Just pause there. It's an hour and a half. I'm exactly 2/3 of the way through, but we're not going to finish this witness. There's been a lot to do, so may we pause there. And I'm hoping that we may be able to continue first thing in the morning with Ms. Callan.
Most certainly. What time tomorrow? Do you want to sit earlier?
I think unless 9:30 is inconvenient for anybody or for Ms. Callan, is 9:30 possible?
Yes.
Sorry?
No, it's fine.
Tomorrow morning then at 9:30.